it's my turn now. My name is Thomas Rickert. Thanks for the kind introduction, and thanks to the organizers for inviting me. And I would like to expand my thanks to Ilya in particular for a perfect organization. I think he deserves a round of applause. Now that was the fun part of my presentation, and now I'm coming into a world of pain. We're talking about the RAA. You've heard in the introduction that this stands for Registrar Accreditation Agreement, and entering into the world of ICANN means entering into a world of acronyms. And so, should you be willing to engage more in this, you have to get used to acronyms. And don't hesitate to ask questions surrounding acronyms, because even those who have been in the business for years don't know all of them. Rest assured. Now, I have split my presentation into 3 sections. First, I'm going to talk a little bit about ECO, because you might wonder why a representative of the German internet industry is talking about this here. Then I'm going to talk a little bit about the study, because there's some news going on with this that might or might not surprise you. And then we're going to dive into the depths of the RAA negotiations. And I will also tell you why you should care. Because you might not be convinced now that this is something that you should get involved in, because you might not be a registrar, and you might say, so what? And I will double check at the end of my presentation whether you still say, so what? Now, ECO is the Association of the German Internet Industry. It's an organization that is now 17 or 18 years old. And while you might not have heard of ECO, you may have heard of the DKIX, which is the German Commercial Internet Exchange, which now is the biggest KIX in the world traffic-wise. And there are an awful lot of international members of ECO that also use the services of the DKIX. And a couple of years back, when there were, when everybody thought that the internet industry was primarily access providers and hosting providers, and ECO would provide services for them, do lobby work, political work for them, nationally and at the international level, and also look for, spreading the word about all the good services that they're doing. Nobody really took care of the interests of the internet industry, which is why I approached the ECO board at the time and I said, well, we have some 70, 80 registrars and some registries even as members. Why not considering to set up special services for them? And they said, it's a good idea, you have to do it. Which I do since, and there's a growing number of registrars becoming members of this organization, and I'm on the GNSO Council, for example. We're also doing a lot of work at the international level, so it's not merely an organization for German members, but amongst these 600 members that we currently have, there are many, many international organizations, such as Verizon, Affilias, Core, NetNames is a member, Key Systems, so there are many, many members of the internet industry that we try to take good care of. And also it has some 20+ expert groups where you can find peers that are interested in mobile services or infrastructure topics, stuff like that. So it's worthwhile checking out the websites. And I'm sharing the names and numbers forum, which is dealing almost exclusively with DNS and domain industry-related subjects. I think since we started this at the end of 2008, we've done almost 30 events. A lot of them surrounding the new GTOD program and informing about that in a more or less neutral manner about the pros and cons, whether to apply, whether not to apply, what the chances are, what the downside is of this expansion of the namespace, and so on and so forth. So please go to numbers.eco.de, and there's also an English section of the website. Now, I wanted to share with you some top news today, because we're going to start the next version of the Registrar Atlas, as we call it, in the coming days. That is a study that is kindly sponsored by Verizon, where we had the idea that we know very little about the domain industry. You have the registries, you have the registrars, but then the long tail is unknown territory, more or less. In my legal practice, I've seen reseller chains with 7 hops. So as a customer, you think you're talking to a registrar, but you're actually talking to a reseller of a reseller of a reseller of a reseller of a registrar. So are you in capable hands? I don't doubt that, but you know, we know very little about this, and this is why we came up with the idea of doing a study that in the first year we just did for Germany, and in the second year we did Germany, Austria, Switzerland, and the Netherlands, because they asked us to participate. And in this year, we have France on top of that, we have Russia on top of that, and they have also confirmed, and we have Belgium that wants to participate, and we have another confirmed member for this study, which is Bulgaria, yes. So you will have the opportunity to participate in that. It's carried out by an online questionnaire that will be publicized in the next couple of days. And there will be questions for you to ask, to answer. It will take you like 15 minutes to answer the questions. And these questions, and I'm trying to move to another area, will be split into different sections. So we're going to ask you questions about, this is the old report that you can download for free. We ask questions about your company. Where are you based? How many employees do you have? Do you serve an international audience, or do you serve a local market? We ask questions about the domain business, like how many full-time equivalents do you dedicate to the domain business? Because there are companies that might have 50 employees and manage like 500,000 domain names. But we want to know how many of your employees are actually working in the domain business, so we can find out what the industry average is of how many domain registrations are handled by an employee. We're also asking about the accreditations. How many accreditations do you hold? Do you serve registrants, or do you serve resellers as well? How many TLDs do you buy from other registrars or from other wholesalers? You know, all sorts of things. We're also asking questions about services and marketing. Are you happy with the support and marketing help that you get from registries and registrars? We're asking them about trends. What services are you currently offering? What services are you going to roll out in the next 12 months? What services are you not going to offer? And in the last 2 years, we found out very, very interesting things. 2 years back, DNSSEC was the flavor of the month, politicians' pet, and we had like 18% deploying DNSSEC already at that time, and almost 40% promised to deploy it in the coming 12 months. So you would guess that the overall market penetration for DNSSEC would be 18 plus 40. It was not. It has decreased just because it wasn't in everybody's attention. We saw the same low demand for DNSSEC in the other markets, except for the Netherlands, where there was huge demand. And if you take a second look at that, SIDN was offering DNSSEC secured, quote-unquote, domains for free. Right? So it's quite interesting to look at those niceties in the market, as well as, do you offer secondary market domain names? And like 50% of all companies that participated in the survey that offer domain registrations don't even consider offering secondary market domain names. So one might think that the customer is too stupid or too ignorant to consider buying a used domain, quote unquote, but it's actually those who offer the domain names. They are the bottleneck. So that's something to think about, or at least to be aware of, because I think we're losing an awful lot of potential. Because the further you go away from the registry, the less TLDs are offered to the customers. So if you look at the services that the companies are providing, you know, so let's say there's a registrar also offering web design and hosting, and that company has like less than 10 employees, chances are quite good that it's a small web design agency. And most of them are offering less than 10 TLDs to their customers. So I think that's something to work on, because I think there is no saturation of the market, and I fully agree with clearly in that regard, but I think we need to make better offers to the registrants so that they can buy. So I think this is enough of a marketing spot for the study. I'm very much looking forward to looking at all the markets that we're now covering. So please make sure that you not only respond to the questionnaire, but that you also read the study and that you provide us with your feedback. Because you, what's happening now? I think
that's the results of the study.
Yeah, so I think I'm going to, maybe with all the changing that was too much for the projector. And what we've also done for the first time this year in order to encourage you, we are giving away 200 vouchers for Amazon or something like that, so that at least you can buy and download legally the record of your choice. So please watch out for that, and I'm sure that Ilya will share the news where to find the questionnaire in the coming days. And we will not only compare the markets, but we're going to do that on an annual basis, so we're going to trace developments. Like Leonid, he said that people don't expect big jeopardy for the incumbent CCTLD with the new GTLDs. For Germany, Austria, Switzerland, and the Netherlands, it was even more so, because more than 90% says that there's no danger at all for the CCTLD. And also, the majority of the companies that we asked said that they foresee their future as very prosperous and better than the average market development. So it's watch out for that. Now, as regards the RAA negotiations, this is the agreement on the basis of which registrars can offer GTLDs. And the negotiations, or the idea of amending the existing RAA started way back when, in November 2011. Law enforcement at the time was not too happy with the way the registrars acted, because there are some bad actors, there are some actors that don't properly respond, I think that's no secret. But then law enforcement came up with their personal wish list. And we're going to look at this wish list in a moment. And not only has law enforcement said what they want to be changed, they got backing of the GAC, another acronym standing for the Governmental Advisory Committee. So the government representatives in ICANN, they said, we saw this list, we like it, we support it. And now how can you lower expectations of governments, particularly when they say that they have consulted with each other and that all is okay and that they want these improvements, quote unquote, for the RAA to be present in the future version of the agreement. Now, the registrars have taken this and have agreed to some points are controversial, and now we come to the complexity. This is seen by the registrars, and I think there's a lot of truth in that, as a bilateral negotiation between ICANN and the registrars. And they also say that it's none of the business for the outside world to get involved with these negotiations. And there's a lot of truth in that too. At the same time, I think it's important for the whole community to look at what is being discussed and what the impact on the industry might be. And there's something which we call the picket fence. So there's a limited area in which consensus policies can prescribe what registrars shall be doing. But outside that, it shall be reserved to the negotiations between ICANN and the registrars. Now you have another third party, which is the governments, that try to influence that. So everybody's pulling strings in the background or even publicly to have an influence on the outcome of these negotiations. Now, the critical issues, and we're going to look at the whole set of issues, or at least most of them in a moment, is who is data validation and verification? Who is inaccuracy is no secret. Many of the who is, or a lot of who is data that you find now is inaccurate. And if you ask me, and I'm speaking only in personal capacity, I would shut down public who is in the morning if I could, because it was invented for different purposes. Now it's being seen as a source of, or it should be a source of reliable information for law enforcement and rights holders, which it will never be. You know, so law enforcement is now looking for accurate WHOIS data. I don't think that can ever be achieved. If I were a criminal, I would use WHOIS records that are perfectly accurate. Only the person in the WHOIS doesn't know about it. So I think that the effects, the positive effects of trying to make WHOIS more accurate are limited, but so be it. That's one of the requests. Law enforcement wants WHOIS to be accurate, and how that's going to be achieved we're going to talk about in a second. Law enforcement also wants registrars to do data retention. They want them to keep data so that at a point in time when they might or might not need data for an investigation, they can knock at the registrar's door and say, hey, I want the data that you have collected when domain name abc.de was registered. They also want the creation of a privacy and proxy accreditation program, because a lot of privacy and proxy services do not respond. Some of them might not even be real business, but just bad guys writing into WHOIS that they are a proxy service in order to camouflage their behavior. And that's one point where I think we're going to see a policy development process at the GNSO level. So I think this is going to happen. But I think everybody in this room can still help shape the parameters of that, right? So watch out for that. There are more obligations. We'll look at them in a second. And not to forget a revocation clause that hasn't been there so far. So what I can basically say is that this market is changing very quickly. And they want to reserve the right that in a changed marketplace, they can revoke the contract. Now digest this. We want, or ICANN wants to be globally inclusive. They want developing markets to enter the scene, and they want business to be stimulated and developed there. If you were an entrepreneur asking some venture capitalist to give you money, and you have to tell the venture capitalist, well, okay, I want to be a registrar, but it may well be that in this rapidly changing environment, ICANN is going to take my accreditation away for whatever reasons that are beyond my control. Do you think the venture capitalist will give you money? I think he will run away as fast as he can. And I think it's not even needed, because if you are acting on the basis of the then valid RAA as a registrar, if the market changes and you are not willing to change with the market, you're going to be out of business. That's what the market is all about, right? But those are things that go more or less unnoticed by the whole industry, that might lurk into the agreement and have quite damaging effects on it. So we have to watch out. I'm going to try again now to go into another document, which is this, which is an overview, and I'm not going to bore you with all the detail, but just that you can see what has been requested by law enforcement. Roughly, I'm going to give you some headlines. So they want registrars to investigate reports of illegal conduct. And the registrars say, okay, that's something that we, at least the good players, are going to do anyway. So that's green light. Then the registrar shall not engage in illegal activity. The good players don't want to do that anyway, but they just don't want to rubber stamp that whatever illegal activity they might get involved in, they should be doing. So they want some, some threshold for that, like, if a registrar is actually intentionally or gross negligently engaging in illegal activity, that should have consequences. But that's also green light. Registrar collection of data regarding registrations in addition to the language already collected. They said it's okay. Registrar abuse contact, and there are some registrars that don't have one. And I think that's a fair request to be made, that at least you can go to a registrar and complain at a specific point about illegal conduct or content under one of the domain names that you administer. So that's also green light. Publication of registrar information, including contact details as well as regular updates to ICANN regarding changes in the registrar business information. That's a point that's more or less settled as well, although the registrars are hesitant to publish home addresses of the directors on the website, which I understand as well, but that's something that can be handled. Disclosure of affiliated registrars and affiliated business. Now there's some complication going along with that, because not only does ICANN want to know who's reselling from, who's a reseller of that accredited registrar, but they also want to hold the registrar reliable for, responsible for activities and wrongdoings of the reseller. And if you have resellers, that's something that you might want to take a closer look at. Then we have privacy and proxy services. I think that's going to happen. There was a first session on that in Toronto to find out what the feelings are and what the parameters should be. So that's going to be in the making, and we should be watching out for that. But that's going to, that's something that you can get involved in. Accreditation of proxy and privacy services is also on its way. Accountability of resellers, we spoke about that a minute ago. Registrar validation of registrant data. I have a special section on that on the slides, but that's actually where all the dynamite is. This is why this only has yellow light, right? And then you have who is service level agreements that the registrars are not too happy with at times, but I think a compromise can be found. And expansion of grounds for termination of the RAA for criminal conviction. So that's basically one of the compliance subjects that Stefan also touched upon earlier, and I think that's playing a more and more important role. We then have, issues surrounding the amendment process. So how can all the existing registrars be moved to the new version of the RAA to provide for a level playing field? So if you have an agreement that's going to be running for another 2 or 3 years, that's something that you might be interested in. Also the consensus policy development and to what extent that can impact the RAA. Are you familiar with the concept of consensus policy? I think that many of you might not be. A consensus policy is something that can be the result of a policy development process within the GNSO. And if a consensus policy is adopted, that has to be followed by ICANN's contractors without any changes to be made to the agreement. So you might think that you have a contract with ICANN, and that this contract is carved in stone for the lifetime of the contract, but actually it is not as far as consensus policies are concerned. So once something becomes a consensus policy, you have to follow it, whether you want it or not. And this is why you also should monitor what consensus policies or what PDPs, policy development processes, are ongoing at the GNSO level, because once this becomes a consensus policy, it might beat you. So I think we're going to skip the rest. Validation verification. Law enforcement wants registrars to do a pre-validation of who is data. What does that mean? We currently live in a world of post-validation, if at all. At the moment, most of the registrars don't validate at all. They just do some plausibility checks in terms of syntax of the data entered. Is this a phone number that actually goes with, that is actually a phone number, or is there an @ in the field where the email address should go? And what law enforcement wants is that prior to the registrant being able to use the domain name, the registrar should validate email and phone number. Which means that at the moment you can go to a registrar, register a domain name and use it. And there are many folks that might want to register a domain name in order to have an email address. So those who don't have a telephone number or an email address won't be able to register a domain name, because that data can't be verified. And you can't use it immediately. You need to wait until the verification process is successfully completed, and after that only you can commence the use. The registrar said we don't like the idea, and we would rather, we agree that something needs to be done, but we want post-validation which means that the name resolves, and they would promise to do, within 5 business days, a verification of one of the 3 data's alternatively, either email address or phone number or postal address. And this is a very, very significant change to the way we register and use domain names. So you can't say, I have a conference tomorrow, I have an announcement to make tomorrow, because there's a new product, and I forgot to register the domain name earlier. You can't register and use if this becomes reality. And also, law enforcement wants to do annual re-verification of the data, which means that after 1 year, they're checking again. If your phone number has changed and you forgot to tell your registrar, revalidation might fail, leading to maybe the suspension of the domain name. I mean, these are harsh consequences. Also, if you're a portfolio registrar, let's say you have 40,000 domain names in your portfolio. I mean, you might think, okay, these are the bad domainers and we're not caring about them, but I know big brand companies that have portfolios, including defensive registrations, accumulating to 15,000 domain names. I think they don't like the who's reminder emails either, but imagine annual re-verification for these portfolios, and somebody just not being interested, or staff turnover in the IT department, so that can easily lead to your domain name not being available. And then you have to find out why this is the case. And so this is something that we shouldn't take too lightly. Data retention. The original request by law enforcement was that registrars should keep data for a period of 2 years after the end of the contractual relationship. Not after the registration, but after the end of the contract. Now for Europe, for example, we have a data retention directive. So those who are in Europe might say, okay, well, we can't accept that, but then we go to the standards in our data retention directive. But even if you compare the data set requirement by law enforcement to the data set that is in the data retention directive, the law enforcement requirements go far beyond that. So even assuming that this would fall, which it doesn't, under the data retention directive, it would go beyond what's legitimately possible for European registrars. I'm not sure whether data retention is an issue here. It is certainly an issue in Germany, and ECO has been fighting data retention for ISPs for more than a decade now. Germany has implemented a law based on the data retention directive that was unconstitutional, so at the moment we don't have a law on that, and we're fighting for it, for not having one, right? So just imagine the impact on your privacy if you know that, if you register the domain name and it will stay, all the payment details, all the IP addresses, your address, your home number, everything stays with the registrar if it were for the wish of the law enforcement authorities for a term of 2 years after the expired the registration. So that's quite substantial. So what we're now seeing is that the GAC is supporting these requests. They have so from the very first minute, and there have been members of the community that have asked GAC representatives, have you double-checked with your local data protection authorities whether these are legitimate requests? And government representatives said, well, certainly, how dare you ask? Certainly we've asked them, and we're okay with it. Then, the Article 29 Working Party, which is an independent group of the national data protection officers of the EU member states, has written a letter to ICANN saying, no, this is illegal. And I quote from this letter, which you find under the link, it's worthwhile reading. The Working Party finds the proposed new requirements to annually verify both the telephone number and the email address and publish these contact details in the publicly accessible WHOIS database excessive and therefore unlawful. The working party strongly objects to the introduction of data retention by means of a contract issued by a private corporation in order to facilitate public law enforcement. And they also say, this shouldn't go into a contract, and if some national state thinks that they need data retention, they should have a law on that. It should not sneak in by way of ICANN. Now, you might think, if the European national data protection officers all say this is unlawful, that the EC would say, well, sorry, we didn't properly check with them, and so we let go of that requirement, we don't want to have it. That's not the case. The EC representative said, the Article 29 Working Party is not the European Commission. They're an independent body. And on top of that, we're not going to comment on this letter, because this communication was directed to ICANN. And the European Commission does not comment on correspondence that is addressed to third party. That's an interesting mixture, I think. And I think, if you are, don't quote me on that, if you are working that way in a private company, you would probably be out of business tomorrow. But that's the situation how it is. Now, how to deal with it? Certainly, ICANN can't prescribe and require a registrar to act in a way that contravenes local law. But the current procedure, or the current thinking, is that you're going to have an exemption procedure. Right? So you go to ICANN and say, well, I don't have a law that allows me to collect and store all this data for the retention period that you would like to have. So I'd like to have an exemption from that. And then a process starts, and ICANN might say, okay, we allow you to be compliant in your local jurisdiction. And I think that's an awkward concept, isn't it? To ask a private company in California called ICANN whether you are allowed to be compliant with your local laws. I mean, isn't that a fascinating concept? Now you might say, okay, then we do this exemption procedure. Amadeo knows very well what can happen to you because they did that for their whois with .cat. They went to ICANN and said, well, we have checked with our local data protection officer, we've checked with the Article 29 group. They all say we can't operate whois in a way that ICANN wants it, so we want this exemption. And ICANN said, okay, we give you the exemption. Next thing that happens is that some other group in ICANN that shall remain unnamed, says we don't like the idea. So they filed a reconsideration request to the ICANN board to reconsider this decision. Not surprisingly, ICANN has turned down the reconsideration request, so .cat is now in a position to operate legally. But if this comes true, what will happen is that, and we have these complexities with whois for all new GTLD applicants, that in theory, we might see all European registrars asking for an exemption with ICANN. We might see all new GTLD applicants filing an application for an exemption with ICANN for their whois, which is hundreds. And we might have a matching number of reconsideration requests against that with ICANN. So I think that's a little bit awkward, but there you go. Now, we might see a fragmentation of the retention periods, if at all, but we don't know how this is going to work out. What we know is that the negotiations shall be concluded soon. The question is, will this happen soon by compromise or by pressure? And if so, what compromise will that be? Now, the timetable published by ICANN is that the negotiation shall be concluded by December. Then, the RAA draft is going to be published for public comment. This is important. PC, public comment. That's your opportunity to make yourself heard. Also in December, that's going to be published. Then, a revised RAA is going to be published in February, taking into account the comments. And then the new RAA shall be approved by April. So I think that's quite an ambitious time frame, although I fully agree that we need to come to closure on that rather sooner than later. But we should be very cautious with this. Because I think that once these requests, if they go into the RAA, are being operationalized, the same measures might be requested for your CCTLD. The bad guys, and I think we can take that for granted, if there is more control for who is in the G space, as we call it, in the generic names, they might move to CCs, where there are no such requirements. And don't you think that it's likely that your local government representative, if he sees this working, and if he sees that the registrars do all this costly verification and re-verification stuff and the data retention stuff, that they might say, okay, if they have all these tools in place, they should be doing that for the CC as well. So I've spoken to a lot of representatives from the CC space who said, so what? Why should I care? But I think they should care, because this is going to change the whole industry. It will not only affect the companies in this business, but it will also change the user experience. And it will be a cost driver. And this has been one of the allegations against the registrars. You know, everybody says, well, the registrars, these bad business people, they just want to preserve their bottom line. They want to remain their profit. But we're not talking about profit, we're talking about cost. Right? So there will be increased costs per domain registration. And if it's only $1 or $2 or euros left, or whatever the currency might be, there is the risk that this excellent opportunity, opening the namespace with all the new GTLDs, this excellent opportunity for everybody at the global level to get their share of this new virtual territory to build their business upon, is going to be limited to those who can afford it. And the question is, do we want that to happen? So I would like to urge you to, if you can, maybe have a chat with your local GAC representative and say, well, do you really think that we should pursue this path? Or don't you think it's still a good time to change your mind and maybe loosen up a little bit? Because, you know, we're trying to catch the bad guys, but we're taking all the good registrants and the good guys hostage. And we're not going to prevent bad business from happening. It's just going to move somewhere else. Right? So we should rather focus on tackling the source rather than, you know, punishing everybody with it. Please do submit comments. I'm going to, you know, under this link, there is a possibility to leave public comments on the wiki for the RAA negotiations. But you also have a chance to send a public comment once the RAA draft is being published. So make use of that opportunity. Alert your colleagues to the issue. There might be registrars or resellers. You know, everybody who's offering domain names will be affected by this ultimately. And maybe raise the issue with your CC colleagues at the CCNSO level. Maybe they even want to engage. I have put a question mark there because there are hesitations, which I fully understand, that they don't want to get engaged in that, but I think that you should at least be alerted to this fact. And as Stefan said, this is a community exercise. It's up to us to shape the future of the industry, not only the GNSO, not only ICANN. But this is one of the aspects that people might think, so what? Well, they should. And now I'm asking the question again, do you still say so what? And I would be surprised if at least some in the audience would say, no, I'm not going to say so what. Thank you so much.
Now I would like to invite our guest lecturers for lunch. Please stand a little bit. You have a question? Okay, you have a couple minutes for question.
Why am I not surprised, Stefan?
I don't know. Stefan Van Gelder speaking. Thanks, Thomas, for a very fair, I thought, presentation and a very realistic call to action. I wanted to get your views on what's happening within the Council as far as these negotiations are concerned. You mentioned in one of the earlier slides that you thought it was fair for registrars to feel that this was a two-party negotiation only. the council, some in the council clearly don't feel that is true or fair. And it's been a problem for a while with these negotiations, both in terms of the pressure put on the negotiating parties and the pressure put on ICANN staff in particular to reach certain objectives that, from what I can see, have never been spelled out by law enforcement. So do you think, I guess my question is, do you think the council is helping or hindering these negotiations?
It's a very good question, and I should point out that I do not in any way represent the council when I'm making my statement. That's really in personal capacity. There's no easy answer to that. Number one, the GNSO Council should not be a party to the negotiations. That's one. There are certain aspects of the negotiations that, in my view, fall into the picket fence, and the GNSO Council should only voice its concerns in those areas that are within the picket fence. So I think it's not appropriate for the Council to get engaged in aspects that should be reserved to the contractual negotiations between the parties, being registrars and ICANN. So what are those areas that are within the picket fence? One of them I've highlighted, and I think that's the primary area of work for the Council to be done, and that's the work that, in my view, requires a PDP, and that's the view of the, I think, all groups represented on the Council, and that's the WHOIS Privacy and Proxy Accreditation Program. We could go through all the list, but it's quite controversial, and I think that you know, that moves from certain aspects should not be dealt with by the Council at all, and others say that it's in the core remit of the Council. So I think it would not be helpful to take the Council's influence on the negotiations to a higher level, because that would actually be a hindrance. But I think the Council plays a role, particularly when it comes to those topics that are within the picket fence, and the Council should assist this by working on this as expediently as possible. Having said that, I'm talking here in personal capacity, yet I'm on the GNSO Council. So there is a difference between my work on the Council and my work outside the Council. And nothing keeps me away from making presentations such as this, to raise awareness on the subject and encourage others to file public comments. And I might even, as a representative of ECO, file a comment on the RAA in the public comment period. So that's another opportunity to make yourself heard. But that's not for the Council or councillors to do in their capacity as councillors or as the Council. I hope that answers the question.